those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score for PDP in those states because they are printed with irregularities. I'm also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the situation room of the PDP on the day of the election. I have seen the report for Kano State in Exhibit PAH-2. Furthermore, in response to the cross-examination of the Lano Senior Counsel for the third respondent, Fabian ESN, the PW21 said, "It is true that I have been following ANEC activities since 1999. There was a time that ANEC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANEC chairman announce 2 days to the election that due to security and cash crunch, elections will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. As stated the role played by each of those persons, I have seen volume 3 of my report. The said volume 3 of my report deals with ANEC documents which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's votes cannot be deducted more than once in a unit. I did not conduct extraction of the BVAS report. I am aware that BVAS machine was used for accreditation. I am the only one who signed the report because I was the team leader. I worked in all the states where alteration took place, including states where PDP won. That's the treatment of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, Supra, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost esteem and value. A close look at the reports, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, wherein he claimed that Form EC8A series were altered and were not signed. It also talked of 15,002 polling units, where Form EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several forms EC8A series had a lot of alterations and that they were not signed by the presiding officers. The law particularly requires that the presiding officers must sign the results. Signing Form EC8A is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature from stamp and any alteration on the forms. Since PW21, who authored Exhibits PH3 and PAH4, did not place this in his report, and the petitioner did not call any of the polling unit agents to testify and place the forms before the court to give vent to the allegation of alteration and non-signing of the Form EC8S for the 5,270 polling units listed in Exhibit PAH2 and the Form EC8S not signed, stamped for the 15,002 polling units in Exhibit PAH3. That allegation is unfounded and not proved as required by the law. On petitioner's allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines made it mandatory for electronic collation system. I have carefully considered the submissions of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent herein, is established by Section 153F(1)(f) of the Constitution, and part of its functions, as stated in paragraph 15, item F, part 1 of that schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has annexed the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) states that a collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that a number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 64. At this stage, it should be noted that Section 47(2) referred to in Section 64(4)(a) relates to procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64, subparagraph 4b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 or Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner as prescribed by the Commission. The Act also provides in Section 60, subsection 5, that the collation officer or return officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collation is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or returning officer will use to verify and collect the results, subsection 5 also provides for what the collation or returning officer will use to collect the results. Subsection 6 of the same section provides for what the collation or returning officer will use to determine the correctness of disputed results where there is a dispute. These are the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed collected result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, Sub 2 of this Act. And D, the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 60, Subsection 4 of the Act, which requires only the accounting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the words deliver in Section 61, transfer in Section 65, and transmitted directly in Section 50, Sub 2, 64, Sub 4, 5, and 6 of the Electoral Act in stating how results of elections should be handled under those provisions. A look at the definitions of those words in the Black's Law Dictionary 6th edition show that the word transfer is defined at page 1497 as to convey or remove from one place or person to another, or to pass or hand over from one to another, or to specifically change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly interchangeably to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all this, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1999 Constitution and Section 148 of the Electoral Act 2022 that the first respondent herein made the regulations and guidelines for the conduct of elections 2022, as well as ANIC Manual for Election Officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation on non-compliance on paragraph 38(1), Roman 1 and 2, 48A, B and C, 50, Roman 5, 7 and 20, 51, Roman 2, 54, Roman 12, and 55, Roman 12, and 93 of the regulations and guidelines. Paragraph 38, those provisions refers to have been reproduced in this judgment. So from the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 621 for the delivery by the presiding officer of the result, along with other election materials under security and accompanied by candidates or their polling agents, were available to such persons as may prescribed by the first respondent. The first respondent has, by paragraph 30 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area for vote collation officer. As stated earlier, the technological device prescribed by ANIC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face, that's facial recognition, thus accrediting the voter to vote at the election. And storing the data and number of such accredited voters. By paragraph 38, Roman 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANIC Result Viewing portal. after which the presiding officer shall take the beavers and the original copy of each of the forms to the registration area reward collection center. From the above functions of the beavers, it is clear to me that apart from using the beavers to scan the physical copy of the polling unit result and upload same to the result viewing portal RF, there is nothing in the regulation to show that the beavers was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It should be noted that ANIC results viewing portal RF is not a collection system. Thus, the Supreme Court in Oyetola and ANIC has explained the difference between the collection system and RF, where Ajim JSC held as follows. As their names depict, the collection system and the ANIC result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit's results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collection. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day, close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of election 2022, and the ANIC Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the result, the presiding official shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines as well as the ANIC manual also state that hard copies of election results shall be used for collation, and it is only where such hard copies of the election results exist. No such hard copy of the election results exists that electronically transmitted results or results from the ANIC will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that it's substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations asserted by them. It is important to note here that although election petitions are sui generis, they are governed by the Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instance case, from the myriad of decisions, the onus is directly on the petitioners not only to establish such through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akinlade and another versus ANIC, Audu and ANIC, Oke versus Mimiko, Kente and Ishaku, Nda Kene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This is Section 66 and 68 of the Act, which have been produced in this judgment. By the law, results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the President as in Section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling units. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of votes, collation and announcements of results, signing of result forms, and publication of results. The results sought by the reliefs sought by the petitioners are declaratory in nature. It is cited in law that where a petitioner seeks declaratory reliefs, the burden is on him to establish his claim. His success is on the strength of his own case and not on the weakness of the defense of the respondents or defendants. See Omishore and Arebeshola and Oga versus Ipiazu. It is also the law that the pleading and the claim of the petitioners determines the burden and the standard of proof that is required. By Section 135 of the Evidence Act 2011, if the commission of a crime by a party to any proceeding is directly an issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. See the application of this provision in the cases of PDP and IG versus PDP and others, APC and another versus Obaseki and others, Suleiman and others versus APC and others. In all these cases, the position of our law is that whenever crime is alleged, even if the case is a civil case, its proof must be that of beyond reasonable doubt. In the instant case, the petitioners have grounds of non-compliance with the Electoral Act 2022 and allegation of corrupt practices. Section 134(1)(b) refers to the ground of corrupt practice or non-compliance. If the ground pursued in any petition is simply non-compliance with the Act and there is no tincture of allegation of crime, the proof required would be on the balance of probabilities. But the standard of proof in any ground that is primarily on corrupt practices would require proof beyond reasonable doubt that allegation being criminal in nature. In the instant case, and on the issues being resolved here, the petitioners tendered some documentary evidence directly from the bar. The objections to the admissibility of most of the documents had earlier been dealt with by this court in the earlier ruling on the objections as to the admissibility of the documents, and some of them have been held inadmissible in evidence. The petitioners called two star witnesses alongside other witnesses. The star witnesses are PW19, Dr. Alex Adum Tar, and PW22, Senator Dino Melai. The sworn evidence on oath of PW19 is at pages 131 to 160 of the petition. In paragraph 23 and 30 of his sworn deposition, Dr. Tar, that's PW19, said as follows: I know that on the face of the Form EC8D, 8 in A in bracket, there are calculation errors as shown and contained in the report of the statisticians, which the petitioners shall rely upon. The non-compliance consists of refusal to